Did you know that the Fifth Amendment actually contains a secret weapon against government overreach that could actually have replaced DOGE, completely eliminating any ostensible need for it? Let's dive into it. It says, no person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. This is the original DOGE, the watchdogs of society. The founding fathers referred to trial juries as a shield against tyranny and grand juries as a shield and a sword. So a grand jury was actually a citizen panel of jurors who could proactively investigate crimes. They weren't part of the government. They could just go around secretly investigating, crime rings, and including in the government, they could be investigating government officials, and those government officials wouldn't even know about it. And so the grand jury could do this and compile all this information. And if the moment arrived when they had enough witnesses, received enough evidence that they believed that they could go on to a trial stage, they would then issue a presentment or an indictment by way of the prosecutor. A presentment is of its own initiative. The grand jury can actually formally accuse someone of a crime, and they don't need the permission of anyone in government to do it. That's extremely important. They don't need to be gatekept by anyone. And so they could actually proactively, you don't have to wait for anybody's permission. This is why this is so powerful. It's because you don't need a DOGE, you don't need another fake branch or agency of government or whatever to go and intervene on your behalf when there is corruption in government. When you have the receipts and you can prove that so-and-so, such and such a government official is corrupt, you go and complain to a grand jury, and then the grand jury investigates, and then they issue a presentment, which requires the judge to and the sheriff and the prosecutor to go and convene a trial jury. They can't say no. They cannot refuse a presentment by a grand jury, and this is a key of knowledge that has been lost. Originally, crimes were prosecuted, capital or infamous crimes anywhere, were prosecuted by grand juries. The grand jury was what caused the trial jury to convene. And what governments have done in many of the states, they have actually discarded and shredded the grand juries and thrown away the key. And what remains of grand juries in most states is actually gatekept by a panel of judges and prosecutors and so on. But it turns out that, for example, district attorneys were not a thing originally under the Constitution. Those are a more modern contrivance. What happened in these prosecution cases is that somebody who is a witness to a crime would appear and testify to a grand jury, which would initiate a criminal investigation in many instances. And then that complainant, that witness, would be appointed by the grand jury as the attorney general over that case. And so you can see that the people actually had power to enact justice, including against corrupt government officials who were not obeying the law. And so if you had a problem of these government officials are too buddy-buddy with each other, the legislature is not, reining in the judiciary is not reining in the executive or the legislature and so on, those checks and balances have failed, you have the ultimate check on them, which is a grand jury. You can go and investigate them, and you can issue these presentments and indictments, and no one gets to tell you no. If there's evidence for a trial that they committed a crime, you hold a trial. End of story.